Good afternoon, and welcome to the Appellate Division First Department. Most of you who have been here know how this goes. I'm going to go through the call of the calendar. I will ask you for the time you need, not the time that you want. Okay? Please understand that the clock is for you, not for us. So I give you the time I think we need based on the reports and the briefs. And should there be more questions, I don't stop my colleagues, okay? So please don't get disturbed by my cutting your time short. I'm giving you what I think you actually need. And if you should need more, my colleagues will tell me so by the additional questions, okay? All right. People versus Enrique Foote. Submitted. W. Children. Okay.
Respondent agency requests 7.
Okay. So 4 and 1, 3 and 3. If I mangle this name, forgive me. Iuculano versus City of New York. I'm sure I mangled it, but I gave it a good try.
For defendants appellants, Your Honor, 7 and 2.
Okay. Okay, 5 and 2 and 5. Digital forensics versus records access officer.
For petitioner appellant, 8 and 2.
Okay. 6 and 1 and 5. Mirza versus Boulevard Retail. Okay. 5 and 2 and 5. People versus Ellen Moskowitz is submitted. Transil Elevator versus First Specialty. Okay. All right. 5 and 2 and 5. Rosario versus Halen Construction. Okay. 5 and 2 and 5. 495 Estates versus New York State Division of Housing and Community Renewal. Okay. 5 and 2 and 5. Sherman versus Zambella. Okay. 5 and 2 and 5. People versus Charles Jones. Okay. 4 and 1 and 4. Gutierrez versus City of New York. Submitted. Bailey versus Gabrielli Trucking. Okay. Seems you've scared away the respondent. Do you wish to submit, or do you want to talk to us for a few minutes?
Unless the panel has any questions, I'll submit.
Any questions? Submitted. Wait till the call of the calendar before you exit, okay? Murray versus Stone.
Good afternoon, appellant requests 6 and 2.
Okay. Respondent? Okay. 6 and 2 and 6. First case on the calendar, W. Children. You may proceed when you're ready.
Good afternoon, and may it please the court. My name is Mara Flater. I'm an attorney at the Bronx Defenders, and I'm here on behalf of the appellant Precious W. In this case, the agency actively and deliberately refused to help a mother who was struggling with acute mental illness until she eventually despaired and gave up trying to work with them. This is precisely what the legislature was concerned about when it included the discouragement provision in the abandonment statute. The abandonment finding was error and should be reversed. But when a different organization stepped in and provided Precious W. with the help that she desperately needed, she was able to turn things around to the point where the family court recognized her tremendous progress and reinstated visitation with her children. Yet when she asked for the opportunity to present evidence and argument showing that it would not be in her children's best interests to have her rights terminated, the family court denied her that opportunity.
Prior to their denial of that opportunity, had she complied with the required mental health treatment that had been for years requested of her? I mean, this is the tragedy of these cases, is that you have people with mental health challenges who don't recognize they have mental health challenges and refuse to do the very things they need to do to keep their children. Right?
Yes.
So while I am empathetic to your client, how about the kids? How long do they have to wait for her to get it together?
Yes, Your Honor, you're right, this is a tragic case. However, in the months, almost a year leading up to the period of that would be the dispositional hearing, the family court had before it a parent who had been regularly and actively and successfully engaging in that mental health treatment. She was stable, she was regularly communicating with the agency, she was coming to court, and she was doing everything to plan for the return of her children.
Could you tell me where in the record there's any evidence that she actually engaged in mental health treatment?
Yes.
I didn't see any.
Your Honor.
So am I missing it?
Your Honor, in the record, in the period of time following the termination proceeding, the termination period covered from January of 2019 to January 2020. However, from December 2020 until October 2021, there are letters from the ACT team that was providing her with intensive mental health treatment to ensure that she was stable. There are
The ACT team?
Yes.
Are those licensed professionals in mental health training?
Yes, it is.
Mental health treatment?
It's a special organization that works with parents who have
But
persistent.
are they psychiatrists? Are they psychologists trained to deal with somebody's mental health issues? Not just the social fallout that happens when somebody has a mental health condition that's not being treated.
To be clear, they're part of North Central Bronx Hospital, and they're the organization that connects the individual with the psychiatrists and therapists, and their letters confirm that she was being seen regularly by psychiatrists and therapists and managed under medication that was appropriate for her,
Okay.
which allowed her to be stable throughout that period of time. So at the time the family court denied her request for a dispositional hearing, it had before it a parent who had radically transformed since the period of time where she was so mentally unwell that she was struggling to do the things that the agency was asking her to do, but failed to provide her with the help that she needed to connect to those services.
How do you explain that your client, in that 6-month period that's at issue here, where it is perceived to have abandoned her children, and I know that she was barred from actually physically seeing them, we understand that, but how do you explain the fact that not a card, not a phone call, not a gift? I do know that on the record she was able to speak to a Miss Jenkins, which was the godmother of the children. Miss Jenkins, of course, had an opportunity to interact with the foster mother. We know against this backdrop we have 3.5 years, something like that, of them being in foster care and being happy where they are. How do you explain someone that you're describing is ready, willing, and able to engage and not even a Post-it? I mean, I'm struggling with that.
So I hear Your Honor's concern. What's important to know is that in the weeks and months leading up to the period of abandonment, she was showing up. She was coming to the agency asking what she needs to do to have her visits with her children reinstated. And every time she came to them and asked for that help, the agency demurred. It said,
But counsel, I'm sorry to interrupt you, the red light there, but that's not answering what you were asked. It's your client had the ability to reach out to the foster mother to engage with the children in some fashion. And why didn't she?
so in July of 2019, right before the period of abandonment, she did have contact with the foster parent, but the foster parent indicated to the agency she was no longer willing to have contact. This was not a kinship.
But that was because she was screaming and being abusive to the foster mother.
So-
Okay, so look, again, this is a tragic situation. But at the end of the day, we have to be concerned with what is in the best interest of these children. right? And I will let you address that when you have time on rebuttal.
Thank you, Your
okay?
Honor.
All right. Next up, you have 3 minutes.
Good afternoon, Your Honors. May it please the Court. My name is Jeffrey Berman, and I represent the respondent, Good Shepherd Services. Your Honors, this is a fairly straightforward case of abandonment. It's uncontroverted in this case that during the
Is a dispositional hearing required where parental rights are terminated because of abandonment?
in a dispositional hearing,
Yeah.
it's not required. It's completely discretionary at the, it's completely up to the family.
And was it an abuse of discretion not to grant that here?
Absolutely not.
Why?
Well, the family court, this has a very long history dating back to 2014. The family court was, the judge was on the case throughout this period. She was completely familiar with the facts of this case, with the mother's compliance and lack of.
But clearly, family court had issues with respect to the agency's inability maybe to connect the mother to services, to stuff like that, correct?
Yeah, I mean, in terms of diligent efforts under a permanent neglect cause of action, the family court did have issues with the agency's referrals for mental health services, things like that. However, for an abandonment proceeding, appellant acknowledges diligent efforts are not required. There's a long precedent that they are not required to be made. And as far as the dispositional hearing, as Your Honor was talking about, this really is not a strong case for a dispositional hearing or a suspended judgment. These kids have been in care for a very, very, very long time. The mother has not been compliant.
Are you suggesting that if a few months before this finding is made, the mother is showing positive movement in the right direction, that would not be a basis for the court to take pause and perhaps have a dispositional hearing in order to flush out whether the mother really has turned the corner?
Given the history.
We are talking about terminating somebody's parental rights.
Sure, I understand, Your Honor, but given the history of this case, these kids have been in care for almost 10 years. At some point, the judge has to say, okay, she has made some progress in the past, she failed, she started again, she failed, she started again, she failed. At what point are we going to say, enough, these kids need to be adopted? They're in a great pre-adoptive home for over 3 years. They've been thriving there. The mother had her visit suspended for almost 2 years. She did not take the steps necessary to get her visits reinstated. I mean, at some point, the judge has to say, no more, we have to get these kids adopted.
Counsel, I'd like to know, is there anything in the record where the mother contacted the agency to request assistance in traveling to receive services or even assistance with securing those services?
I'm not sure if during the 6-month abandonment time period, there certainly are not. However, there's a long history in the past before that. It's possible at some point she did. I can't say for sure. But even so, I mean, the agency, during the 6-month relevant time period for abandonment, there was no contact at all from the mother. She didn't contact, she was unable to contact the children because of the order of protection. I'm sorry, yeah. But as far as contacting the agency, there was nothing stopping her, and that's what she was required to do under the social services law to defeat a finding of abandonment.
Thank you.
Thank you.
You may proceed.
Good afternoon, Your Honors. Judith Stern on behalf of the children. As has already been argued in this case, there was the abandonment clearly was proven in this case. As Your Honors have pointed out, the mother did nothing to contact the children, did not provide any gifts, did not send letters, did not send cards, money, and when the few times she showed up at the agency, she never really was not to meet with the caseworker. It was really in some ways to complain. And when the caseworker repeatedly reached out to her and attempted to make contact with her, she said, I don't want to talk to you. I don't want to hear from you. Why are you asking me questions? She was not particularly cooperative with the agency. As far as disposition, by the time of disposition, the court was well aware of what was going on. This judge had presided over all the permanency hearings that the appellant goes into depth on in their brief. And the court had all the information it needed to know that it was in the best interest of the children at this point, who had been in care for an extended period of time, who were in a very good pre-adoptive home, who were not even asking for their mother at that point anymore, that it was in their children's best interest to terminate the mother's parental rights, and that a dispositional hearing at that point was not warranted. Unless your honors have any other further questions, I'll rest on my brief.
Thank you so much. You have 1 minute on the rebuttal.
Thank you. My adversaries have argued that the family court had before it all that it needed to make a determination about the best interests of these children, but it didn't. The family court had before it information that showed that the parent before them had changed fundamentally in the period of time between the period of abandonment and the period that they would hold a dispositional hearing. Yet they didn't have any current information detailed about her level of functioning, her stability in her home, her employment. It also had reinstated visitation between her and her children, yet had no current information about how that bond was being developed, whether the children's therapists who had been supervising those visits had opinions about whether supporting or severing that bond would be emotionally damaging to these children in either way. And finally, the family court did not have any current information before it about how these children were doing in this foster home that we hear is so great. There was no detailed information or permanency hearings that were conducted, and the family court did not have critical information that would have helped it understand whether these children were really looking to be adopted by this foster parent, if this foster parent was really going to adopt these children. And the fact that the family court denied this parent the opportunity to present that evidence prevented it from making a decision based on a complete record.
Thank you so much. Ukulano versus City of New York. That one's gonna bother me through a whole day. Counsel, how do you say the name?
I say Ayukulano.
Ayukulano.
That's,
Okay.
you know, it's not easy. James Strauss, Your Honor, from Louis Brisbois, on behalf of
proceed.
defendants appellants. Your Honor, there are 3 reasons that Justice Hagler's decision should be reversed. First, his decision is inconsistent with Court of Appeals precedent. Second, his decision did not consider the fact that Mr. Ayukulano gave multiple stories.
Well,
as
there are 2 versions of the accident, okay?
to 2.5, I would say.
Maybe 2.5, however you want to characterize it.
Yes.
But is plaintiff entitled under either version of the accident, under the defendant's version of the accident, wouldn't plaintiff be entitled to 241 finding a liability because he was struck by an object?
Well, the first thing I'd say is that here we have Mr. Arapi's testimony that totally discounts what Mr. Ayukulano said.
I'm saying under the defendant's version of the accident. Put aside.
Under defendant's version, no, there is no, at best, it's a worker negligence case, a loss of grip case.
I'm sorry?
I said it's at best a negligence loss.
200, it's best a 200 action, is that what you're saying?
I'm sorry?
It's a 200 action.
At best, yes.
How's that? He wasn't hit by a falling object?
He was hit by a falling object, but it was a loss of grip on the base of the.
By another worker?
Correct.
Correct? Okay, so your argument, as I understand it, is that the worker, by losing grip, was the sole proximate cause of the accident, correct?
Yes, not the injured person. Yes.
The other worker?
Yes, correct.
Can't there be more than one cause of an accident? Couldn't the accident occur because there was inadequate protection as one cause, and another cause could be, as the defendants say, the worker lost the grip, as a result the structure fell?
I'm glad you raised the inadequate protection issue because that's crucial in this case. Fabrizi, Narducci, Runner all say the same thing. You have to be injured as a result of a gravity-related accident, and you also have to either be provided with a safety device, an enumerated safety device, or that safety device has to fail. And in this case, Mr. Tomich, our expert, made it very clear that there was no reason that, the braces were perfectly safe. The braces were never.
Apparently not.
No, they didn't fail. Mr. Ayukulano doesn't claim they failed. The braces never failed. It was an appropriate safety device. In fact, Your Honor,
What's the appropriate safety device used here?
the braces. And the braces were
And
used.
yet still, he was hit by a falling object. So
As a res-
something failed.
Not a falling object, the base,
He was hit by a falling object.
the base.
Are you really going to contest that here?
The base.
Are you really going to contest that this man was hit by a falling object?
A pipe on the
Which
scaffold.
fell on him.
It wasn't dislodged, but yes, a pipe fell.
It fell on him.
I don't dispute
Okay,
that.
so we
let's-
agree that this is a falling object case. So tell me what
Correct.
device, counsel, I'm still talking. Tell me what device was utilized to prevent that object from falling
The
upon him?
braces. The braces were used to raise the scaffold.
So they failed then?
They did not fail.
Because what fell on him was not prevented from falling by the braces. Am I
It's like-
correct?
No, you're
No?
not correct. The braces held. The braces held. The braces didn't fall. The scaffold itself did not fall. It shook.
So what fell?
What fell?
And what prevented it from falling?
The braces prevented the sidewalk shed from falling on its body.
Okay, let's start again.
Surely.
Something fell on this worker, correct?
Unquestionably, but that,
And something did not hold that something from falling on him.
yes,
Okay.
a coworker.
Okay, and tell me what case says that that 240 sub 1 liability is obviated because a coworker is negligent.
The case that I will point you to, Your Honor, is a case that you brought in Fuentes, where there was an
that-
unrebutted.
Counsel,
unrebutted-
I saw that and
May I answer or may I not?
go ahead, you may answer.
Okay, so it's a case that
But
you
seeing as
said-
I was on that case,
You were.
it doesn't say what you think it says, but please go ahead.
It's certainly a case where there was an unrebutted plaintiff's expert, and that unrebutted plaintiff's expert made a sufficient showing for there to be a 240 claim in that case. Here, we're entitled, this court has repeatedly given deference to expert testimony. You yourself, in the Fuentes case, you yourself in the Bonaire case, gave great credence to expert testimony. Here, our expert says that there was braces used and it was the appropriate way to use them. Second,
So then,
it was
but
industry standard.
counsel, my colleague has asked you about 3 times.
Yes.
The braces did not prevent the object from hitting plaintiff. Therefore, it seems to me that the brace was not a sufficient safety device under these circumstances.
If that's your position, that's your position, but I don't believe that's what the law.
Well, but the thing is, you keep saying that's your position. The man was hit by a falling object.
But not every-
So obviously, there was something lacking to prevent that object from falling and hitting this man.
So is your position that every.
Hey, you know what? Unfortunately for you, you don't get to ask questions of the
I'm
court.
not saying, I'm not asking you.
Well, you started by
What
asking
you're
me
saying
a
is
question.
every falling object case is an automatic 240 claim. That's not the law.
That's not what we said, but you'll have time on rebuttal.
Good afternoon. May it please the court, Kelly Breslauer for the plaintiff respondent. I think the court clearly understands the facts here, and it's our position that regardless of the version of the incident.
Can you address your adversary's point that there's a expert's report saying that the braces were provided adequate protection and that we should essentially, based on that, presumably find there's an issue of fact with respect to 240 Parens 1 liability?
Sure. So it's our position that, as this court's well aware, when plaintiff moved for summary judgment, an expert affidavit isn't required to establish a violation. And yes, counsel did put in an expert affidavit stating that the braces were the only safety device needed and that it was a proper method of erecting the scaffolding. But there's a couple things there. The first is that it doesn't address the fact that this pole fell on plaintiff. So the expert's affidavit doesn't raise an issue of fact because he doesn't dispute that it fell. And secondly,
Does the expert affidavit explain how, despite the use of the braces, which supposedly, according to your adversary, are the safety device at issue here, why those failed to prevent that pole from falling?
Your Honor, I'm looking at it now, and I don't believe he explains why it failed. His position is more that this is just the proper means and methods for construction cases, and this is the method in which the scaffolding was erected was proper. And so his position
So basically, if a pole falls, well, we did everything we could.
yes, and so then two, he then opines that there's no 240 subsection 1 violation, which, as this court's aware, an expert, when there is a violation, cannot opine as that statutory violation. And so it's our position that the expert affidavit doesn't raise an issue of fact, as the trial court held. And lastly, if we want to just go a little further, and we do take defendant's foreman's affidavit as the version, I mean, he even testifies that before they erected it, he says that we ensured each beam and pole were properly secured by shaking and moving each pole to test for any looseness. But then the pole still fell. And so ultimately, this is a clear runner falling object liability situation. And so if the court has no further questions.
Well, what about the, I'm sorry.
Go ahead.
I was just going to ask you, with respect, your adversary says it's essentially a 200 case because the grip of the worker slipped, which caused the object to fall.
Sure.
What's your response to that?
So I think there's two things. I mean, just recently this court, and I believe Justice Kennedy, you were on the case, it's Rincon, and so there a wrench fell from 10 feet above, and it was, the facts, if I'm remembering correctly, were that the co-worker just lost grip of the wrench, and the facts and the court held that the wrench should have been tethered. And so here, even if the idea is that this pole that plaintiff was provided is supposed to help support, erect this scaffolding, which, you know, the poles weren't necessarily, you know, they were hollow, 4 inches in diameter, and then there you had 100-pound steel plates on top. So you were using these poles, which the Court of Appeals has also said, you know, braces should not be used to lift completed structures. They're supposed to be attached to them. But if you're using that pole to lift it up, and a worker loses their grip or readjusts, I mean, if you think about this logically, that's only a few seconds. I'm sure he re-grabbed it, but even if he didn't, under defendant's theory, this pole is supposed to support the weight. So if he does lose his grip, the scaffolding the pole should have never fell on plaintiff. And there's been cases, again, I think Bonneray, Justice Mazanet, you were on that case where they were lowering a portion of the sidewalk and plaintiff was just helping two coworkers and they lost their balance and it fell onto plaintiff, and that was a 240 subsection 1. So with respect to a coworker losing their grip or losing their balance, it doesn't prevent a finding of 240 subsection 1.
Has there ever been any case reported in this jurisdiction, and for that matter, any jurisdiction, that says that a co-worker's negligence somehow alleviates the statutory defendants of their obligation to provide a safe workplace?
My understanding is no, Your Honor. And my understanding is that even ordinary negligence doesn't break the chain. So if there's no further questions, I'll rest on my brief. Thank you.
Thank you. You have 2 minutes, counsel.
Your Honors, the grip cases that we cite in our opening brief are all grip cases that are outside the context of 240. Another point I'd like to make, Your Honor, is that with respect to his multiple statements about how the accident occurred, which plaintiff concedes were inconsistent and disparate stories, Justice Singh, you were on the panel of Medrano, where the court in that instance had a very comparable situation, where a eyewitness coworker disputes the way an accident occurred. The court in that case reversed.
But the question is whether under your version of the accident, whether or not there's 240 Prince 1 liability. I agree there's inconsistency between the versions, but that's really the operative issue, right? Under your version, whether there's still 240 Prince 1 liability.
But shouldn't a jury be able to hear inconsistent statements from the plaintiff? Shouldn't a jury, certainly if this case gets reversed, plaintiffs will come up with their own expert at trial, as they're entitled to do, and they could refute our unrebutted expert testimony.
Are you suggesting that there's not case law in this department that where there are conflicting theories, that we haven't held that even under the defendant's theory there was liability?
I don't recall any in their briefs, certainly,
But you still haven't answered how, under the defendant's theory, 241 liability would still not be
because this is a loss
sustainable.
of grip case, just like the cases that I cite in my opening brief. Two people holding a pipe, for example. One of them drops it. That's a
Counsel,
gravity-related.
we have cases in this department all the time.
You do.
Where the issue is that one of the workers loses grip. That does not absolve the GC and the owner of liability. It just doesn't.
I completely agree, because in
So I
those
don't see how
instances,
this is different.
in those instances, there is proof that a enumerated safety device failed. And here, we have unrebutted expert testimony that says otherwise. I mean,
Okay.
that's the case.
All right, thank you.
Thank you, Your Honors.
Digital Forensics Unit versus Records Access Officer.
May it please the Court. The Legal Aid Society by Benjamin Berger for Petitioner Appellant Digital Forensics Unit. Your Honors, this case concerns the erroneous grant of a motion to dismiss for failure to state a claim by Supreme Court in an Article 78 proceeding. Supreme Court made 3 errors in granting the motion to dismiss. It applied the wrong standard of review, it misanalyzed the evidentiary material in granting the motion to dismiss, and it misinterpreted this Court's decision in Empire Center for Public Policy versus New York City Office of Payroll Administration. At the outset, Supreme Court applied the wrong standard of review. Supreme Court used an arbitrary and capricious standard of review when reviewing
But counsel, wouldn't it be fair to say, if you look at the order of Supreme Court, that really in substance what the order was discussing was error of law?
Judge, Your Honor, I would not agree with you. In fact, I think if you look at Supreme Court's decision, it failed to actually analyze any of the evidentiary material that was submitted by petitioner in this case. For example, petitioner submitted an advisory opinion from the Committee on Open Government, the state agency that's tasked with interpreting, analyzing, applying the FOIL laws. That advisory...
You agree that while the agency can consider that opinion, that opinion is certainly not binding on them, nor is it binding on this court.
Your Honor, I would agree that it's not binding on this court. I think
Nor on them.
Absolutely.
Okay.
But I think there is case law from this court and from other appellate divisions that state that the opinions of the Committee on Open Government should be afforded some weight. They are a state agency. They're interpreting a statute that's under their jurisdiction. So I think there's some weight that can be given to their interpretation of the statute. But I would not suggest that it's binding on this court.
Okay.
That advisory opinion determined that the public safety exemption should not apply to the precinct rosters at issue in this case. It analyzed both the history of the FOIL statute.
Can you tell me, because I was most interested, having not gone on to the new website that is available, it would have been something, as a former legal aid attorney, I would have loved to see, right? So tell me, what is it that you are seeking that is not already available on this website?
So, Your Honor, in fact...
Other than it being neatly broken down for you, precinct by precinct, it seems that the website would have the names of all of the officers in the NYPD. Am I correct?
Yes.
Okay. So then tell me how you've been injured, since this information is arguably available otherwise.
Well, at the outset, when this FOIL request was filed, obviously this online database did not exist.
Okay.
And during the pendency of this litigation, the city posted this online database, which includes, in fact, more information than was sought in the FOIL request. However, I'd note that this database wasn't posted pursuant to any sort of statute or regulation. It was posted voluntarily by NYPD. Presumably, it can be taken down at any time by NYPD. It could be taken down if there's a change in NYPD leadership. It could be taken down if there's a change in mayoral leadership. Additionally, NYPD clearly doesn't have any obligation to update this database. It's not regulated by any sort of third party. So we're operating under NYPD's generosity. And in fact, the purpose of our FOIL request is to make sure that this information is available if NYPD chooses to take this database down, or if they choose not to.
Well, wouldn't that concern be better addressed by the city council, perhaps, or the New York State legislature, rather than this court?
Well, Your Honor,
Because it's almost like you're asking us to legislate from the bench, then.
well, Your Honor, we're talking about the context of a motion to dismiss for failure to state a claim. And really what this boils down to, is this information, which is now publicly available, is it covered by the public safety exemption in 87-2F? I don't think it's a logical argument for the city and NYPD to claim on one hand that this information is covered by the public safety exemption because it could threaten the lives of a police officer, and then on the other hand, they can post a public database with the same exact information.
Except that the way in which, and please correct me if I'm wrong, because I already said I haven't gone on the site. I am assuming that the site lists these names alphabetically. Am I correct?
You can sort it by different fields. So you can sort it by the precinct they're assigned to, you can sort it by last name. You can
Well,
sort it by-
then, counsel, if that's true, then why is this not moot?
Well,
Why do you not already have everything you're asking for?
again, I would reiterate, they can take this down at any time.
I know, but that's not where we are today. And this court is not going to issue a decision about what may happen later. We never do that. So right now, right, this court is dealing with this case based on the current context. And the current context is that all of the information you're seeking in this request is available.
What I would point out, though, is that we're not here in the context where a Supreme Court decided that our FOIL petition and our Article 78 was moot. That's not what the ruling here is.
Well, I'm not saying it's moot, right? But I'm saying what you're asking for, you have available to you. Am I wrong?
I would disagree only to the extent that we have a decision by Supreme Court that this information is covered by the public safety exemption. So if the city, if NYPD took this information down and we file a FOIL request, there's a decision from Supreme Court that says that this information is covered by the public safety exemption. And I think that would frustrate our ability to get this information. Any sort of settlement.
But except counsel, it seems to me that if that occurs, wouldn't you have an argument to be made in a future FOIL request if it was taken down, that how can you claim a safety exemption when for a period of time all the information was up? So isn't that a battle for another day?
Well, Judge, I would just point out, Your Honor, that was the argument that was made to Supreme Court, and Supreme Court came up with this decision that determined that your decision in Empire Center created this prior disclosure rule where any prior disclosure is not relevant in determining whether the public safety exemption applies. So while I agree with you, we can make that argument in the future, it's actually was determined by Supreme Court in this case.
Okay.
Thank you.
You may proceed.
Good afternoon, Your Honors. Julie Steiner, the attorney for the respondent. The only question in this Article 78 appeal is whether the decision, when made in 2019, was reasonable based on the then legitimate concerns of public and officer safety.
But it's strange. How are we supposed to make that decision when you release the information? And if we were to accept what the Supreme Court's saying, the information's already out there. So there seems to be an inconsistency.
Well, in response to your question about whether this was moot and what he got already, we're a little perplexed by that too, although he is seeking the roster from 2019. So to the extent that's why it's not moot, in 2019, the NYPD, the records officer, made a reasonable judgment call that based on giving out the precinct rosters of every officer in every precinct throughout the city would create a public safety risk. And regardless of what happened 2 years later, this Article 78 appeal only...
Isn't there an inconsistency with that position?
Yeah.
Isn't it inconsistent?
No, Your Honor, there is no inconsistency. There may have been
You have that affidavit from Miller talking about, oh my God, all
Yes.
the bad things that are going to happen, yet you put all the information out there for everyone to see anyways.
So My adversary claims that it was not in response to any statutory change. The issue is that in 2021, when the repeal of 50A occurred, the NYPD, in order to maintain and to be more transparent, yes, had to put out there the disciplinary records of police officers. But it made a decision to also balance that transparency as well as the public officer safety information, and made the decision to publicly make this information publicly available. That occurred in 2021 in response to a change in the law does not mean that in 2019, those records should have been, that the decision to not disclose those records was an error of law or was improper. At that time, it was absolutely proper to do that. The NYPD at this point, yes, with this transparency and with what is on the website, it's continuing to assess the situation and assess what is going on with the precinct information. But again, in 2019, which is the only period of time that this court should be looking at in reference to the decision, FOIL decision, it was an absolutely proper decision by the records officer, and the Supreme Court did not err for that very reason. The court should not look to whether something occurred 2 years later in a different period of time for different reasons. And for that reason, Your Honor, we ask that this court affirm.
You know, I have to, speaking only for myself, the fact that there was this publication of these names, to me, made it easier to confront this case. Because as I read through the papers, I thought, well, hell, based on this argument, there's never a time when anything can ever be disclosed based on that analysis. So I'm a little troubled by your position, because for me, the comfort came in, well, what are you complaining about? You now have everything you were looking for. But you're saying to me, I shouldn't look at that. And if I am to assess it that way, then I have to decide, well, is this blanket no reasonable? And I don't know that I'm with you when it comes to that.
I understand your concern because we do have this new publication out there. But in any Article 78, you must look at when the decision was made. And at the time, this information was not publicly available, the precinct data, in other words.
Was the Staten Island information revealed prior to this decision?
Yes, it was.
So then that argument kind of loses a little of its flight. I'm sorry. Because Staten Island is this little place, this little island. Come on. If I can have all the names of all the officers in Staten Island, which is this insular place, right? And it would seem to me that the police department would be more concerned about the safety of this insular island of people than all of New York City, where your officers live all over the place.
Correct. Yes. I'm sorry.
I don't see the logic there.
With the Staten Island issue, that was a one-off request, and then as soon, or almost a year later, this broader request, the NYPD made the reasonable determination that greater amount of information out there poses a greater risk to the public and a greater risk to the officers. So again, in 2019, when it made that decision, having been faced with a request to give the names of every single officer in all 5 boroughs, it made the reasonable determination to not disclose it on public safety. And for that reason alone, the court should affirm. Thank you.
Thank you.
Your Honors, I just want to reiterate that the fact that NYPD released the Staten Island rosters without pushback in that context, but did say that the entire boroughs couldn't be released, doesn't really make sense under a public safety exemption analysis. I would also point out that here, Supreme Court used an arbitrary and capricious standard in deciding this case, not an error of law standard. And I think that goes to the fact that Supreme Court didn't look at the evidentiary material that was presented by petitioner. It didn't weigh the evidentiary materials between each other. It looked...
Counsel, how did you respond to the Miller affidavit, which talked about harm, potential harm to police officers? How did you rebut anything in that affidavit of what that affidavit said.
Well, the first thing we pointed out was the Miller affidavit was actually not drafted for this Article 78 proceeding.
understand.
And it didn't actually address the facts of this case. The Miller affidavit actually concerns retired NYPD officers. And a big point made...
So, wait a minute, but do you think retired New York police officers are at more risk than current police officers?
That's what Miller says in his affidavit. He says that...
I don't think he says that they're more.
He says that because they are not under the protection of the Threat Assessment Protection Unit, retired officers do not have the same level of protection as current officers. He also makes the point that because these retired officers aren't showing up to roll call every day, they're not checking in with a supervising officer, if something happens to them, no one would know for an extended period of time, as opposed to a current officer who, if they miss roll call, there's going to be a...
But that's not to say, because that statement to me left the impression that retired officers experience more incidents of potential retribution by former arrestees, let's say, right, than someone who's currently on the job. There's nothing in the record that would support that statement. Am I correct?
No, and again, I'm just relying on what Miller put in his...
Okay, you and I are reading Miller's statements differently then, but that's okay. That's okay.
Counsel, I like to go back to the evidence. We talked about that Miller affidavit, but the advisory opinion, which we already know is not binding, in that advisory opinion, wasn't that just focused on law enforcement and had nothing, the purposes of law enforcement, having nothing to do with safety concerns? Was that even addressed in that opinion?
Yes. What happened was, after the denial of the FOIL request, the Legal Aid Society, through the Digital Forensics Unit, specifically sent a request for an advisory opinion based on the facts of this case to the Committee on Open Government. And what they advised was that the particularized showing necessary for the public safety exemption was not present in this case. There was no indication of an actual threat to anyone. So it directly addressed that threat analysis. And I would also point out, the Miller affidavit contains a number of factual parts that are not really accurate in today's environment. For example, the Miller affidavit says that criminal defendants are not given the names of the officers that arrest them or are involved in their cases because of the threat to the safety of those officers. The state legislature, in the discovery reform, passed 24520D1, I believe, where all criminal defendants are now entitled to the names and work affiliations of every officer that has relevant information about their case. So the Miller affidavit, to the extent it was filed in a different case, it addresses a different set of facts, is not really relevant to this case at all, and can't make that particularized showing. Thank you.
Thank you. Mirza versus Boulevard Retail. You have 5 minutes. You may proceed.
Thank you, Your Honor. May it please the court, Andrew Fisher on behalf of the appellant. It is our contention, Your Honors, that the motion court erred in granting tenant respondent's motion for summary judgment on the ground that the indemnification provision was triggered by the plaintiff's claims. First, the plain language of the indemnification provision is not triggered by plaintiff's common law allegations of negligence against tenant. Looking at the indemnification provision, it states that landlord would indemnify the tenant only for claims, judgments, etc., arising out of or resulting from any such violations of applicable law relative to the HVAC unit. So given that language...
Why isn't a negligence claim, why wouldn't a negligence claim fall within violations of applicable law?
So I think looking at that language, but also given the history and which tenant admitted was the indemnification provision was written because of municipal violations issued by the Department of Buildings. So that indemnification provision is directed at governmental and municipal liability and violations of applicable law, not common law negligence.
But respectfully, it says penalties, fines, costs, liabilities, or losses. It's much broader than you're making it, isn't it?
Well, to that point, I would note that the violations that were issued here are directed only at how far away the cooling towers were from the residential units. So any indemnification that landlord is hypothetically required to give to tenant would be limited to that sort of thing related to the distance the cooling towers were from the residential units.
Well, you don't say that. You could have said that in the provision. You don't say it.
Right, but it's limited to
The provision is
violations
written
of
much
law.
broader than what you're making it out to be, no?
I think it's limited by the language it's saying violations of applicable law, and given the fact that respondent admitted that it was directed at those municipal violations that were issued just before this provision was drafted. And looking at the violation, given what that's directed at and the context in which this was drafted, and then looking at plaintiff's allegations.
Counselor, you recognize that we are bound by the four corners of what is actually written, right?
Correct.
So whatever happened, whatever discussions, whatever the context for the ultimate agreement are really irrelevant unless they are memorialized in the writing itself.
Correct.
So tell me where in the writing you believe you are covered.
So I would say.
Without the, well, you know, in the context of what we were negotiating. I want to know what's actually in the statement, as my colleague has said.
Absolutely, Your Honor. So looking also at the other provisions, so the supplemental termination agreement was to amend the termination agreement. So essentially.
Oh, in effect, you got $7.5 million to permit an early termination at least. That's what you got, right?
Right, and that was written because tenant addresses this point. That was written and that sum was decided on before this indemnification provision was ever drafted. So that really doesn't have anything to do with the indemnification. That was written in the context of terminating a lease which had approximately $9.5 million worth of rent remaining underneath it. And I would also note the termination agreement also has a survival of claims provision, which states that nothing in the termination agreement should be construed as a waiver of any claims or rights of either party relating to.
No one is suggesting there's a waiver here. The issue is whether or not the tenant is entitled to contractual indemnification.
Right, but I think in that context, given that neither party is waiving any rights it has related to environmental claims or third-party liability, that plaintiff's claims of common law negligence against tenant, which don't have anything to do with violations of applicable law, which don't have anything to do with code violations.
The basis of negligence claims is the violations of the applicable law, that the cooling towers were too close to the windows and noxious fumes came in, et cetera, et cetera.
It also has to do with their use of different cleaning products, not cleaning the towers properly, and other things that happen to them, not violations of a particular code. I would also note the termination agreement also states that both parties are, or that tenant specifically is required to maintain its obligations under the lease up to the date of termination. So in the lease, it states that tenant is required to indemnify the landlord for any, just have to find the language, I apologize, but for any fine or violation from a municipal or government agency in connection with tenant's use and occupancy of the devised premises. So I think given that language, that it applies up to the time of termination, there's conflicting language. There's nothing in the termination agreement or the indemnification provision which gets rid of the indemnification provision in the lease, and so those two are at odds. The tenant's required to indemnify the landlord for the same thing that it's claiming it's indemnified for, and they fail to reconcile those 2 points.
Okay, you'll have time on rebuttal.
May it please the court, Michael Prisco for the respondent. I first want to address the applicable law language and the expansive nature of that language. Specifically, as you could read in the agreement, it's violations of applicable law relative to the HVAC unit. So if the parties wanted to limit it to municipal liability, as the appellants say, they would have used municipal liability. And we make, we very much highlight in our brief that the parties were aware that there were municipal violations. So if the parties wanted to limit the liability that could arise just out of those municipal violations, they would have said it. And they didn't, because this was a lease termination agreement. They knew liability, there could be more liability arising out of those municipal violations. So they used the language that needed to be used, and that was very expansive language that would include not only the municipal violations, but also common law negligence, statutory violations, or common law negligence based upon statutory violations.
Is there an inconsistency? The lease obviously has a provision saying that you're going to indemnify the landlord for acts and omissions, et cetera, the standard stuff. Is there an inconsistency between that indemnification provision and what was negotiated upon termination?
No, I do not.
So
No.
then how would those two provisions function?
If I understand the question correctly, is the question, is there an inconsistency between the underlying leases
That's
indemnification?
right, where you're required to indemnify the landlord versus this provision where the landlord, the lessor, must indemnify the lessee.
No, for two reasons. Number one, the underlying lease is null and void. That's why we have a lease termination agreement to memorialize the splitting of this relationship. And secondly, and this goes hand in hand with the claim that there was certain environmental liability or third-party liability survives as per the termination agreement. If any of those additional provisions supersede here, you render the lease termination, the supplemental lease termination indemnification language and provision, you render it meaningless. For example, in their brief, they make an argument that when looking to the survival terms that, well, the parties retained third-party liability, and this is a third-party liability claim, right? Then the indemnification language, the expansive indemnification language, talking about potential third-party liability is rendered meaningless. And interpretation, you can't render that language meaningless. So that's how I would address that question, Your Honor. If Judge have no other questions, that we could submit on the brief. Thank you.
Thank you. You have 2 minutes on rebuttal.
Thank you, Your Honor. So addressing respondent's point as to the survival of claims, I would direct Your Honors to the language of that provision, which states that the parties are essentially not giving up any rights or remedies that they would have under the lease relative to third-party claims or environmental liability. So looking at that, that means that both the tenant and the landlord have all of the rights and obligations that they had under the lease relative to environmental liability claims and third-party claims, which is what we're dealing with here. And under the lease, tenant is first obligated to indemnify the landlord for exactly what it's arguing here. And then tenant was also specifically forbidden from causing the exact type of injury that was caused here and allowing vapors or fumes to emanate into residential units. So tenant's incorrect that those provisions are null and void because the language of the indemnification provision that they're citing to allows landlord to go back to the lease and use specifically those provisions which are rights and remedies that it had relative to third-party claims and environmental liability claims like this case. So those provisions do survive and tenant is still required to
Well, would they survive maybe up to the termination date? Those issues aren't really before us because you haven't moved for contractual indemnification on that, but presumably that may be one way of looking at it. Post-termination, this is what the parties agreed. But it's not, that's really not before us, correct?
No.
But I think that those raise issues of fact, and given also that we argued that this provision is void, and in which you do look.
Well, let's talk about that. It's void under the GOL?
And the common law, Your Honor.
Okay, so let's go with the GOL. What part of the GOL applies to the lessor? Wasn't this provision passed to protect tenants?
That's correct, Your Honor. And
are there any cases that say that the landlord can use this essentially as a sword.
Not that I'm aware of, Your Honor, and so given the fact that the lower court and the parties both addressed that, we address it in like manner, but we also cite to the common law, which mirrors the general obligations law in 5-321, but doesn't limit it to just the lessor-lessee relationship there, but essentially requires the same things. There has to be a clear intent from the parties in which you would look outside the four corners of the document, and there's no evidence of that here. There's been no depositions, no findings as to the ambiguous terms in this document, for which there are no definitions provided, no context. And the context that we do have is that this was written to address directly and only municipal violations, and there's no evidence. So in our view,
It wasn't just municipal violations. They were already aware of the infant plaintiff's complaints. So when this was drafted, they were aware that there were tenants already complaining that they were suffering physical consequences of the vapors from the cooling tower. So I don't think that's an accurate statement.
I'm taking that from tenants'
I'm taking
brief.
it from the record. And at the point that this termination agreement was entered, all of those facts were on the floor. Your clients were fully aware of that situation. Am I incorrect? Have I read the record wrong?
Not to my understanding, Your Honor.
Okay. All right. Thank you.
Thank you.
Transl Elevator versus First Specialty.
Good afternoon, Your Honors. May it please the Court, John Leonard, Anderson Kill, representing Appellant Transl Elevator. Your Honors, this case presents issues of insurance coverage, and it implicates a number of longstanding principles under New York law, bedrock principles that the underlying trial court misinterpreted in its summary judgment order.
Well, cutting to the chase here, it is your view that the liftgate on this box truck that was used for unloading material for the elevator contract is the equivalent of a cherry picker constituting moving equipment, which would be an exemption to the auto exclusion clause of this insurance contract, correct?
Correct, with the stipulation that under the language of the policy, the liftgate, based on the language of the policy and based on the allegations of the underlying complaint, the liftgate qualifies as a similar device under the auto coverage extension to the auto.
Similar device being one used exclusively for raising and lowering personnel, which a liftgate is not designed to do. We understand that.
Well,
I mean, it may have been used. I mean, someone could jump on it and go up and down. Let me do it this way. How do you reconcile your position with our court decision in Countrywide versus Excelsior Insurance?
Because, Your Honor, the cases, including Countrywide, the cases cited by First Specialty, don't analyze facts that implicate the coverage extension to the auto policy. The coverage extension that's at issue here was not analyzed in the Countrywide case, because here, what makes the liftgate itself similar to a cherry picker under the definition of, under that single paragraph, F2 of the definition of mobile equipment, is the fact that it's attached to a truck chassis and it was used to raise and lower Mr. Pimentel. There are.
But is it supposed to raise Mr. Pimentel? As I understand it from the record, a liftgate is not supposed to be used to raise human beings, but items, products, boxes, whatever's on the truck. It is supposed to be used to push the material that's on the truck onto the liftgate in order to lower it to the floor so that workers can then carry it to wherever it has to go. It is not supposed to be used for a human being to be lowered down to the ground.
But Your Honor, the policy itself does not say that the device needs to be used for any sort of intended purpose.
I thought that the very statute we're looking at talks about a cherry picker being used to move a worker up to a site where they need to work where they could not otherwise work, right? So a cherry picker lifts a worker up to a pole to fix electrical wires, for instance, something like that.
Right, but under the language of the policy, under this definition of, under this specific paragraph, under the definition of mobile equipment, paragraph F.2, which triggers the coverage extension to the auto exclusion, all that requires for the device to be a, quote, similar device is that it be attached to a truck chassis and that it's used to raise and lower workers. And that's exactly what the underlying complaint here alleges. It alleges that Mr. Pimentel, the plaintiff in the underlying action, was using the lift gate to go up and down.
Except wouldn't this lift gate have to be used for just that purpose to qualify? Because under the definitions, right, of what an automobile is, right, it can include here the truck had a lift gate attached to it. It was still an automobile. It was used to transit back and forth, whereas a cherry picker is just used for that purpose, in order to lift workers up to achieve work height for whatever their assignment is. That's not the case here.
I do understand your point, Your Honor, but the coverage extension and this paragraph does not say that it needs to be used exclusively for raising and lowering. And as a matter of fact, in the summary judgment briefing in the underlying case, not in our coverage case, but in the personal injury case, Judge Bluth addressed a similar argument that the liftgate itself was not intended to raise and lower work, or the liftgate was intended to raise and lower materials.
Right.
Judge Bluth didn't credit that argument because Judge Bluth said it was completely reasonable for Mr. Pimentel to be standing and using the liftgate to make sure that the equipment that was being used, that was being raised and lowered on the liftgate didn't fall off. It was a
That's a completely separate point, it seems to me. You're talking about a worker using a platform maybe in that instance, but here what you're essentially saying is that a cherry picker is a functional equivalent of a liftgate, and a cherry picker seems to me is a platform that can be used, a working platform at heights, as my colleague said, so that workers can access what they have to do on poles and buildings, et cetera.
I'm saying, Your Honor, that under the facts alleged in the underlying complaint and the language of the policy, in this instance, the language of the policy dictates that the liftgate qualifies as a similar device. It's not a universal, so if a liftgate was on the ground, was not raised to height on the back of a truck, and someone was walking along and tripped over the liftgate, it would not be used to raise or lower work. It would still be attached to the back of the truck because it's not being used to raise or lower worker. That would not trigger the duty to defend. In the allegations of the underlying complaint, the liftgate was being used to raise and lower Mr. Pimentel. So in that instance, in this specific factual...
There was no equipment? Didn't you just say that there was actually equipment on the liftgate that was being lowered with the worker?
Yes.
So it's being used, in effect, to move equipment up and down. The worker happens to be on it to guide it down.
That's correct. And under the coverage extension, that's all that's required.
Go along for the ride.
Is that
I don't know that the worker is guiding anything. It's a mechanical apparatus. You push a button, the liftgate goes down. You push another button, the liftgate goes up. All he does is stand there. And he's not supposed to stand there. But I got your argument. I'll hear you on rebuttal after I hear.
Thank you, Your Honor.
Pardon me. Alexandra Rigney on behalf of Respondent, and may it please the Court. I merely want to address a few points that were made in the argument before, rather than going through the whole history of everything. The provision, the extension, as it's referred to by appellant, and I would refer to as an exception to the exclusion, has a paragraph that precedes the provision that appellant wants to rely on. And that provision says that the vehicles not described, ... maintained primarily for purposes other than the transportation of persons and cargo. And so in this case, the box truck is primarily used for the transportation of persons and cargo. So it does not line up to say that a cherry picker is the equivalent because it is not used primarily for the transportation of persons and cargo. Sorry.
Does it matter, as your adversary argues, that on the facts of this case, that in fact the worker was using the lift gate with equipment on it to go down and up?
Your Honor, I would address sort of the differences between a liftgate and a cherry picker just for the purposes of answering your question. The liftgate is only going to rise to the level of the box truck. It's not going to go any higher than that. Whereas a cherry picker, the purpose of it is to raise a worker to a height that they couldn't otherwise reach with, say, a ladder, for example. It has to go up even higher than that, for example, as you had indicated, to reach wires, to fix them, or higher than the level of a ladder. And to answer your question—
So it's a work platform, in effect.
It is a work platform. And in fact, I realize that the Rufa case is not from this jurisdiction and that you're under no obligation to rely on it. However, I do think that the definition that they used in that case is very persuasive. They define a cherry picker as a maneuverable vertical boom with an open bucket or cage at the end from which a worker can perform work high off the ground. So although Mr. Pimentel may have been on the liftgate when the accident occurred, there's no evidence that Mr. Pimentel was using the liftgate to raise himself up to perform work at a height. And so it's our contention that the exception to the exclusion does not apply. I would just address two more arguments that were raised in the briefs. One, appellant seeks to bring back into coverage this claim by referring to the exception to the contractual liability exclusion. Respondent concedes that that exception would apply, but for the fact that coverage is already excluded under the auto exclusion, and therefore relying on that exception is not going to bring it back within coverage. And finally, our last argument is that the case is premature. There's a $250,000 self-insured retention. That is the responsibility of appellant, and until that self-insured retention has been exhausted or there's proof of it being exhausted, there's no justiciable controversy for this court to decide.
Thank you.
Thank you.
You have 2 minutes.
Thank you, Your Honor. Just to address counsel's points, whether there's a difference between, or whether this liftgate itself falls within the definition of an auto or the definition of mobile equipment, the policy doesn't require that distinction. The coverage extension only requires that the equipment be listed within that specific paragraph of mobile equipment to trigger the coverage extension. So the remainder of the definition of mobile equipment, starting with the language that counsel quoted, is not relevant only for the purposes of the coverage extension to the auto exclusion. It is if you're looking at the definition of mobile equipment as a whole, but in terms of the coverage extension, it's not relevant. As to the Rufa case should not serve as any guiding precedent here, aside from the fact that it's from New Jersey. The Rufa case involved a small.
Forgive me.
I worded that poorly. I'm sorry. But, the Rufa case involved a small child who got his arm caught in the liftgate. The liftgate activated accidentally, and the child was injured. So under the facts of Rufa, that would not trigger this policy either, because the child was not a worker and the child was not using the liftgate, as Mr. Pimentel was, to raise and lower himself while he was doing work. The Rufa case also didn't analyze the duty to defend. It was, they were talking about indemnity there. And even if it had analyzed the duty to defend, New Jersey law differs from New York. New York's duty to defend is exceedingly broad. Your Honor, you mentioned the four corners rule before. Duty to defend under New York, if the four corners of the underlying complaint allege facts that could potentially or possibly be covered under the four corners of the insurance policy, the insurance company's duty to defend is triggered. And to counsel's last point about the timeliness of this action is timely. For one thing, the self-insured retention is almost exhausted. Transcel did not plead a cause of action for breach of contract. We pleaded cause of action for declaratory judgment, only seeking a declaration from this court that the insurance company's duty to defend has been triggered so that when that self-insured retention is exhausted, First Specialty will step up and do its duty, its contractual obligation under the policy. This is
Don't you have to put forth those expenditures before the court can make that kind of determination?
Yes, but the court can make a declaration that the policy has been triggered even if the First Specialty doesn't have to, because of the self-insured retention, if First Specialty doesn't have to step in and defend immediately. When that self-insured retention is exhausted, First Specialty will act in accordance with the court's.
Right, but who gets to determine that if there's no documentation before the court, right? So
Well, if we were talking about a breach of contract where we were seeking current damages, then yes, that would be correct, but we're just.
would you not have to, at the very least, provide the insurers proof that you have already expended $250,000 before they're triggered, right?
Correct, before they have to come in and actually defend and start spending the insurance company money under the limits of the policy to defend the action. We can seek a declaration, and declaration is proper one way or the other, as to whether or not this underlying complaint triggers the defense obligations under the policy.
Okay, thank you.
Thank you, Your Honors.
Rosario versus Halen Communications. You may proceed.
Good afternoon, Your Honors. May it please the court, Jack Newhouse for plaintiffs' appellants. This is an appeal from the dismissal of a putative class action for unpaid wages on behalf of a group of construction workers. The complaint is pretty straightforward. The plaintiffs allege that they were required to report to the defendant's yard in the morning, perform prep work, and then travel to the construction sites, perform work at the construction sites, and then travel back to the yard. Here, the plaintiffs claim that the defendant's practice was to only pay them for that field work, the work that was done at the construction sites, and not for the travel time or the yard time in the morning.
Isn't there an indication in the daily reports that the plaintiffs were getting 2 to 8 hours of overtime? Correct?
Well, you said the right word, which is indication. Perhaps.
Well, maybe my question wasn't that as precise as it should have been, but go ahead.
Well, no, Your Honor. Keeping in mind the pleading standard on a motion to dismiss, the daily reports, which I believe you're referring to, which reflect the time, reflect a time start and a time finished. So
you're saying it doesn't capture the 5:30 a.m. arrival at the yard?
Well, exactly right. So under the pleading standard, the plaintiffs pled that at 5:30 and 5:45 they showed up at the yard, whereas for Plaintiff Lewis, there is not a single daily report that shows him showing up before 6:30. Now that discrepancy, the defendants would argue that it conclusively refutes our claim, but we would argue that actually conclusively proves our claim. That if we establish that he really did show up at 5:30, 5:45 in the morning, a fact that must be accepted as true, that difference in time is precisely his damages. Going on to the daily reports simply do not capture the work that was performed, that the work plaintiffs performed. They reflect the work that they were paid for. And that's evident from the foundational affidavit from Mr. Hickey, which states that the daily reports reflect the work that they were paid, not the work performed. And that, unfortunately, the trial court construed that to mean all work performed, not all work paid. And so
it seemed clear to me from the papers that your basic argument, as my colleague has pointed out, is that the time before the 6:30 hour, it seems like all of the daily reports register most of the workers as beginning work at 6:30 in the morning. And those daily reports also cover some overtime hours at the back end of the day, correct?
Well, that's.
I'm not saying that it's
No, I know,
inclusive of everything. I'm saying that what the daily reports capture is work from 6:30 a.m. forward, right? And did capture overtime hours at the end of a shift, right? So that if they, or are you suggesting, because as I read the complaint, I wasn't sure whether you were suggesting, I was clear, I think, that you're saying that on the front end of the day, these workers were shortchanged the amount of time that they arrived at the site and the time they actually arrived at their actual field work site, so that that time was not covered. Am I correct?
Yeah, well, I understand, yes.
And now, is there also time that you are alleging at the back end, at the end of the day, where they did additional work that wasn't covered, and was that at the yard? Or
Yes.
was that at their field site?
No, not at their field site. It also covers the back-end work at the yard and travel time from the last site to the yard at the end of the day. And I would just state that they use the term overtime, and that's totally fine that they could use the term overtime this way, but the way they use it is not exactly the way that it's defined under the law as hours worked over 40 in a week. They use it as they see fit, meaning extra time that they pay the workers in a given day.
Okay. All right. Okay. You'll have time on rebuttal.
Thank you.
You may proceed.
May it please the court, Henry Masha, attorney for the defendant, Halen Construction. Supreme Court properly dismissed the complaint here. The daily reports and the payroll records combined flatly contradict the allegations in the complaint. The daily reports show the time that each worker started, the time each worker ended, and the location.
Does the court address the allegations of the plaintiffs here where they allege, because all of the daily reports have all of the workers starting at 6:30 in the morning. But we have some plaintiffs saying that they got to the yard at 5:30 in the morning, 5:45 in the morning. So I'm trying to understand that conclusion below.
Sure.
If I've got a plaintiff saying, well, every day I got there at 5:30 in the morning, but I only started getting paid at 6:30.
Right.
So how was he properly paid?
Because there are daily reports that show when they reported to work before 6:30.
But we have to assume, I'm sorry, counsel, we have to assume for the purposes of this motion, the truth of the allegations of the complaint, as my
Correct.
colleague says, as your adversary says, that it's pre and post work that they say they weren't paid for.
Right.
That's the allegation. Your reports show that there were payments from 6:30 on. That doesn't negate, or that doesn't utterly refute their claim that there was work pre and post that wasn't paid.
But we have reports that show that when they arrived before 6:30, they were paid for it. On page 369 in the record.
Are you saying that
started
none
at
of the
3:30.
complaints, that none of the complainants here made allegations that there were days that they arrived before 6:30 that they were not paid for? There are allegations by some plaintiffs that say they got there at 6:30 and weren't, at 5:30 and they weren't paid for it. Am I right about that?
Yes, they make that
Okay,
allegation.
so
And
they make that allegation. All right. Well, this is not a summary judgment motion, correct?
No, it's a motion to
Okay.
dismiss based on
So doesn't the court
documentary.
have to accept all of the allegations as true from a plaintiff in a
That's right.
in a dismissal motion?
Absolutely.
So
But the-
how does this utterly refute? How do the documents that your client provided utterly refute the complaints of these plaintiffs?
Because the daily reports show the days that they did report before 6:30.
And the
And
report
they
cannot
defend-
be inaccurate or incomplete?
Well, hang on a minute. The complaint never says that we were forced to underreport our time. And don't forget, the plaintiffs here signed the vast majority of these daily reports. So all of their criticisms of the daily reports assume that they misreported and underreported their time
And
deliberately.
if they didn't sign it, would they work the next day? If they had a complaint about what the form said, would they be able to come to work the next day?
Your Honor, if the complaint had said, I was forced to underreport my time because the company made me, then that would be a different story, but they don't make that allegation. And when plaintiffs have a legitimate claim...
Do they agree with your daily reports that those are complete and accurate and a fair representation of the actual hours they worked?
You know what? We don't know because they didn't submit anything in response. And they very easily could have submitted an affidavit that just said...
It's not an evidentiary motion. They don't have to
true,
do that. You chose to bring a 3211A1 motion, and it's your burden to show that it utterly refutes their claims. And I will submit to you that it's not clear to me that you've shown that, and nor does Supreme Court below address the gravamen of their claims here.
Counsel, I'd like to also ask this with respect to the daily reports, because I don't really see anything indicating that the workers were paid for travel time to the job sites or even the prep work, at the yard. Where is that in the daily report?
Because when the work happened at the yard, it was listed on the daily report. That's how we know. And there are plenty of daily reports that indicate when they worked at the yard and when they didn't.
Okay, let's talk about the travel time. Where is that? Because I didn't see it. Where is that?
It doesn't list out travel time here, but when they worked at the yard...
That's what they're saying. They didn't get paid. That's what they're saying.
But when they worked at the yard, it's listed on the daily report as one of the job locations. There are absolutely record sites where that's exactly what happened. And if we look at page 585, 698, all these daily reports show when they did work outside the job site. So that utterly...
About the travel time returning to the yard, as your adversary argued. How do the reports capture that travel time?
They do. All of these reports capture the travel time. 119, 127, 419, 346, they talk about travel time every time that the workers actually traveled. So that refutes the allegations in their complaint. And they did nothing to respond to say, and they very easily could have said, we underreported our time because the company made me, but they never did that. If you were a plaintiff facing dismissal of your entire claim based on a 3211 motion, why wouldn't you just submit an affidavit that says the gravamen of your complaint, which is I underreported my time? Why wouldn't you do that? That's why Supreme Court dismissed their complaint, and that's why this court should affirm. And I would just close with one final point, Your Honor, if I could.
Counsel, you are 2 minutes over time already. I'll give you 20 seconds.
I'll get 20 seconds. This is not your typical case where you see 40 hours of regular time and then the plaintiff says, I was paid overtime. These plaintiffs were paid massive amounts of overtime. I mean, you have days where they worked 14.5-hour days. Where is the unpaid overtime there? That's on 332 of the record. Lewis, 14 hours.
Counsel, stop. Just stop. 2 minutes.
I'm not going to be up here for 2 minutes, but I would just turn the court's attention to, and this is pointed out in plaintiff's papers, to 150 in the record, where basically it shows the yard, and then it shows 3 job sites, and then the yard at the end. And next to the 3 job sites in the middle, it identifies all the hours that are reflected on the daily report, but there's no hours next to the work at the yard. So all plaintiffs are pointing out is that there's an ambiguity here, there's a lack of foundation, and it's just insufficient for defendants to meet their burden on a motion to dismiss pursuant to CPLR 3211A1. And unless the court has any other questions, plaintiffs rest on the brief.
Thank you. 495 Estates versus NYS CHCR.
Good afternoon.
You may proceed.
Your Honors. Please the court. My name is Jonathan Minikis. I'm the attorney for the appellant. So we were here, yes, we were here over a month ago. We argued a very similar appeal. I was the respondent. So I'm sort of hoping we keep the trend and the appellant's successful. That's my hope. So I recognize the decision, and I'd like to address it, and with as much respect as I can show, maybe establish that the court wasn't correct, and perhaps you'll
But even if it's incorrect, aren't we bound by that decision? Forgetting about the two of us.
Well, no, I mean, I think the Supreme Court might be bound, but I think this court can reconsider a decision that it made. I don't think stare decisis necessarily applies to the same court. So I would submit you're not bound, and I'd appreciate if you would at least attempt to explain why I think the court should, in this case, reconsider what it did in the other case. So in the decision that involved a different apartment, same building, same project, you know, we can all acknowledge that. The court cited the case of Lightview LLC as precedent that this court had ruled on before. And I mean, that case is so distinguishable from the facts in the within proceeding, in that Lightview involved a landlord's attempt to install an elevator shaft through an apartment to take in excess of 60 square feet away from that apartment, reconfigure the kitchen, lose counter space, food preparation space, a pantry, a cabinet. It eliminated a portion of the backyard, and it really reconfigured the apartment. You know, I wouldn't be up here arguing that appeal because that made sense. But in this case, as you know, we're discussing the installation, and in that case, the court pointed out that that wasn't something that was legally required. That's something the landlord wanted to do, to make money. That's not the case here at all. It's the opposite.
Mr. Minikis, no one is questioning on this record that the landlord got DOB approval for this. No one is questioning that there was an attempt to resolve a problem, and this is what your engineers and your people thought was the right way to go. So we understand that. But there's a difference between whether something is okay under DOB rules and regulations and whether something constitutes a diminution of services. And I use the term very broadly because we understand what we're talking about. And the question becomes is, as I have a tenant of an apartment where normally gas lines would be inside the wall or behind the stove and without any access to it from any quarter, suddenly you're now confronted with it, as you described, very unobtrusive little area in the living room, you can barely see it. I'm not making light of it, I'm just saying, is that a qualitative difference versus the quantitative description that you described in the other case that was cited? And now as a tenant, having to deal with whatever it is I do in my living space, now I have this gas line with this pipe there. And I have to figure out a way to be in that room and make sure that nothing will ever happen so that something hits it or there could be a leak. There could be leaks behind the wall, but at least with that kind of exposure here. And that's the issue here that doesn't change from the facts that were in the other case, unless there's something in this record that's different from the facts in the other case.
No, Your Honor, I can't argue there's anything significantly different, but I just want to address what you said. You said the landlord thought it was doing the right thing. Well, the landlord thought it was doing the right thing because the landlord was following DHCR precedent in 40 Central Park South and in a matter of West 49th Street, which did deal with the same issue, the installation of a gas riser. And the court, we believe incorrectly, found that in those cases it was replacing an unexposed gas riser with an exposed gas riser, but that's not the case, and that's particularly clear in West 49th Street, where the tenant had pointed out that the prior gas pipe had not been exposed.
I just want to go back because I see it differently here because we're talking about West 49th Street, and certainly there was not an allegation regarding a defect with installation or that it affected the use and enjoyment of the premises, which is not what we have here. And if I'm not mistaken, I thought that the installation dealt with a cosmetic issue, that they would just be affected in a cosmetic manner. But that's not what we have here.
No, Your Honor, respectfully, I think that's exactly what we have here. There's no evidence at all in the record or in the other record that there was any defect whatsoever. It was all cosmetic. The tenant complained it was cosmetic.
The rent administrator noted that the gas pipe was installed in an unworkmanlike manner on a living room wall, reducing the living room space. The pipe also obstructed the living area. That is not what happened in 49th Street.
Your Honor, there was no evidence of anything unworkmanlike manner. We point that out in the brief. It's just something that that they said, but there was nothing unworkmanlike
There
manner.
was a inspection report,
but
confirmed the allegations.
But Your
there
Honor,
were photos.
The photos
You can't
don't
argue
show
with the
anything.
photos.
And the inspection report.
Can you argue with the photos? I mean, look.
Your Honor, the inspector did not, and you can, read the record and the return, point out anything unworkmanlike. And if there was, the DOB comes back, they would not have approved it. So with all due respect, there is nothing at all in this record to show. That's a point we make. It doesn't look great. We agree. You can make your own subjective opinion whether it looks good or not, but assuming it doesn't.
It's not about that. It's
cosmetic.
what
That's
the inspection found. They said.
But Your Honor, that was arbitrary and capricious because there's nothing, it may not look good, that doesn't make it unworkmanlike, in a unworkmanlike manner, and the DOB would not have approved it. And
All right, you'll have time on rebuttal.
There was anything potentially dangerous. Okay.
Thank you.
Thank you very much.
Good afternoon, Your Honors. I never thought I'd say this, stare decisis, but that's my 2-minute joke. Thank you for your time. I have pictures, as you've mentioned, pictures show the situation. The other case of 495 Estates was actually less blatant as opposed to this case, as you will see. There's a whole pipe going from ceiling to floor to ceiling.
But ultimately, is that we're deciding whether it's less or more blatant?
No.
This is an Article 78 proceeding.
That's correct.
What's the standard that governs us?
Arbitrary and capricious, and based on DHR is allowed to rely on its inspection reports. It's allowed to rely on precedent, and the cases that petitioner in the Article 78 has mentioned as precedent are not precedent because West 49th Street actually says that the replacement of one gas pipe previously existing, in other words, was replaced with a new gas pipe. 40 Central Park South is not a precedent because we don't know if that case was actually talking about an already existing pipe, a pipe that was replacing a previously existing pipe, or that the pipe in question was a newly installed pipe. So petitioner has no basis to say that DHR violated its own precedents. In fact, DHR followed its own precedents because if from 1973, this tenant has not had a gas pipe existing in her living room. And I would say that I'd be dumbfounded to have somebody put a gas pipe, an exposed gas pipe, in my living room. I think that falls under disruptive practices. Counselor tries to distinguish light view by using the word reconfigure, which is exactly what this matter is about. They've reconfigured the use and enjoyment also of the tenant's living room. They reconfigured the use of the space, the configuration of the tenant's living room, as well as her kitchen. As I was mentioning, 2522.5 B and G require the landlord to continue on the same terms and conditions of the lease rental. So counsel petitioner keeps saying that defective and dangerous conditions are the only reason for DHR to not permit new piping. That's not accurate. That's only part of it. I'm sorry, Your Honor, did you ask a question? No. So it's not only that it can't be defective and dangerous, which is, yes, obviously, but it also has to be in line with the terms and agreements of the lease agreement. Since 1973, as I said, this tenant has not had any pipes in her living room. Judge Tisch had it correct. Judge Tisch said that there was uncontested, that space was taken away from the person's living room. There was no violation of due process, as the plaintiff, the petitioner, already knew what was in the inspector's report. They're the ones who did not deny that space was taken. There was no due process violation, no violation of DHR president, and the fact that DOB permitted the work permits to go ahead does not mean that the work had to be done in such manner. There's two different jurisdictions. Any questions?
Thank you.
Thank you.
Thank you. Your Honor, first of all, the photographs, I object. I mean, this is the second time this has happened. You have the record, and I mean, I didn't even have an opportunity. I guess somehow that was, given to the court report. My experience before this court, you're bound by the record. I mean, you can enlarge any photograph and make something look worse than it is. The photographs are on the
Counsel,
record.
this is a pipe that goes from the ceiling to the floor, smack in the middle of a living room wall. And if that were my living room, I'd be in this court too.
Well, because cosmetically you may not enjoy that in your living room, but this was a $500,000.
This is called a penny wise and pound foolish. Instead of correcting this problem correctly by opening the wall, fixing the pipe, laying that pipe inside the wall, and putting some more, this is not a difficult repair. The same work that was done to put this ugly pipe on the outside of her wall and smack in the middle of her living room wall, in between the things she has hung and her artwork. Now she has this ugly black pipe.
Again, that's
from the ceiling to the floor.
That's a blown-up photograph, but let me just explain, and it's in the record, Your Honor. Again, this was not penny, but this was a $500,000 project. It wouldn't cost anything more.
Then they should have put it in the wall where it was originally.
This is what was recommended, and the reason it was because if it went in the wall, it would have markedly inconvenienced the tenant more. Then you'd be talking about bringing down walls. So they did a very extensive asbestos abatement, and they installed it in the manner they were advised and with DOB approval. So please, this was definitely a $500,000. This was not, nobody was penny pinching here. And again, I
would it have cost more to break the walls?
What?
It would have cost more to break the walls.
No,
and
I don't know.
You cannot stand there and say, oh, we spent $500,000 to fix this, and then tell me, but it would have been just as cheap to do it right. But we chose not to do that.
I don't think, Your Honor, I don't think there's anything in the record, I'm not being disingenuous, to suggest that there was another way to do it that would have been more.
There was another way to do it. Replace the pipe where it was, in the wall. So all it took was cutting out. I mean, you didn't have to bring down the whole wall. It's called you cut the sheetrock where the pipe is. You pull out the sheetrock, you fix the pipe, and then you add another piece of sheetrock, and you tape it, and you spackle it, and you paint it.
It would have, as in the record, would have exposed the residents to additional
as opposed to a lifetime, as opposed to a lifetime of an unsightly pipe in the middle of their living room.
Cosmetically unappealing, but that's not the standard.
Okay.
I think what I can't escape, notwithstanding the aesthetic argument of this or inconvenience, we can't escape the fact that this is a gas pipe as opposed to a heat riser. And we all understand that gas pipes have risks that are far different than a heat riser would. I mean, and that, to me, that's very compelling here. Putting aside whether, it's ugly and all that other stuff, and it takes away from their use of that, being able to put a desk where that pipe is or a chair where that pipe is. We know that even even when you install piping in a kitchen, there are concerns about how the pipe work would have to be behind a particular appliance. Make sure you don't put your stove too close to the gas pipe, or your dishwasher too close to the water pipe, or the refrigerator too close. It's in the manuals. There are discussions about sufficient air circulation, all that other stuff that's above my pay grade here. So we're talking about what was never here before, a gas pipe that has its risk of leaks and all kinds of other stuff. I mean, hopefully there won't be. But it's a very real thing to have a gas pipe in a living room versus a gas pipe behind a stove in a kitchen or in the wall. You don't see that at all?
Well, Your Honor, no, we're in agreement that if this constituted a dangerous condition, that would fall within the DHCR precedent. But it did not, and the DOB would not have allowed this if there was, nor Con Ed, nor any, if there was a risk of danger. So I understand your concern. I agree with your concern. And we would be having a different discussion. Again, I would not be up here in that situation because that is consistent with the DHCR precedent, that if it presents a dangerous condition, but you can search this record up and down, and the record in the other case, up and down, there is not one allegation at all, not an iota of any evidence that this is dangerous. And I think you're surmising to say that it is, and that just isn't the case here.
Thank you.
Thank you very much. Have a nice day.
You too. Bye. Sherman versus Zambella. You may proceed.
Good afternoon, Your Honors. May it please the Court. I'm Jonathan Hedelstein. I represent the defendant's appellants. Underlying all of the causes of action alleged in the complaint is the plaintiff Adam Sherman's contention that Agnello Zampella gave him an approximately 10% interest in Cottonwood and waived the formalities that would otherwise have been required of new members. He is alleging both a written and an oral agreement. However, his written agreement is based on two emails that were not sent to him. They were emails that Mr. Zampella sent to Cottonwood Vending's counsel.
Isn't that corroborative of his position that there was a course of conduct between the parties here that modified the operating agreement, in part corroborated by those emails, and in part what the plaintiff says, in effect, that he took less money, provided sweat equity, based on the promise that he would get anywhere between a 9 and 10% share in the company?
Well, our position with regard to an oral agreement is that while this operating agreement was not a model of drafting, there is on page 48 of the record, section 10.1 of the agreement, a requirement that executed copies of any amendments be kept, which would necessarily imply that any amendments have to be in writing, because otherwise executed copies could not be kept. Further, in the section 3.2 of the agreement at 45 of the record, it does require new members to deliver a written instrument agreeing to be bound by the terms of the operating agreement, which we would...
I'm sorry, Counsel, doesn't this agreement that you are holding your hat on in terms of the formalities, and I get it, also have a provision 3.1, which says something along the lines of, upon approval of 65% of the ownership, a new member can be admitted on the terms and conditions as the company sees fit. Hold that thought. And we have Mr. Zampella as 100% owner of the LLC, and it was in his wisdom and approach to send the emails to his counsel saying, hey, this guy is a 10% owner. We got our ticket to the moon with this license, and the second email that pretty much confirmed that arrangement. So he can change anything he wants under the very agreement that you're holding your hat on.
Well, Your Honor, I believe if you look immediately below that to section 3.2, conditions for new members, it begins notwithstanding anything contained herein to the contrary. No person at any time shall be admitted as a member unless, da-da-da. And I
Well,
would
what's the
submit,
da-da-da?
well, among other things, delivering a written instrument agreeing to be bound by the terms of the agreement and any amendments thereto.
Was that agreement would have to be some kind of document from the company itself, no?
It doesn't.
So here Mr. Sherman was supposed to create it himself?
There's nothing that would prevent him from creating a written instrument himself if he believed he had been made a member and delivering it to the company.
Your arguments would hold more water, but for the emails, which suggest, in fact, that there was some kind of amendment to that document, and presumably it's just as simple for the company to provide the document for the plaintiff to sign as it is for him to create that.
But if he felt the company was failing in that regard, it was within his power to provide the instrument himself and say, you know what, you didn't do your part of it, but now I'm a member. And the notwithstanding anything contained herein to the contrary part of that clause, I would submit overrides any, as the company sees fit in the previous clause, that even if the previous clause is to the contrary, then notwithstanding that, the new members.
So how does the last clause not totally wipe out the former? Seems like it means nothing then if the following provision that you have just highlighted wipes it all out.
Well,
it means nothing then.
I would submit that it doesn't. I would submit that it could set, upon such terms and conditions as the company sees fit, could mean the percentage of interest given to the member. It could mean the responsibilities given to the member. It could mean, I would submit, is a reference to the terms of the membership, not to the terms upon which membership can be offered, especially given that the following clause begins, notwithstanding anything contained herein to the contrary.
Okay, so the last one wipes out everything before it. Got it. You have time on rebuttal.
Thank you, Your Honor.
You may proceed.
May it please the court. Douglas Hirsch from Sadis and Goldberg for the respondent. What's particularly troubling about my adversary's first argument regarding the emails is he knows very well that he is not allowed to make arguments about documents that are not in the record. And the emails are not in the record. And he could have attached those emails to his motion to dismiss, but he chose not to, his co-counsel chose not to do that for some reason. And I know it sounds like I'm saying, oh, I don't want you to look at the emails, but I brought the emails with me today. And guess what? My client is copied on the emails. And they're right here. I'm happy to have everyone look at them. So this is why we have this rule that if it's not in the record, you're not supposed to make arguments about documents that are not in the record. But if anyone wants to see the emails, including my adversary, they're right here. My client's copied on them. And the first email that he says was sent to Latham and Watkins, the email about redoing the org chart and making my client a 9.9% member, that actually wasn't sent to Latham and Watkins. That was sent to people internally in the company. And there's about 6 people copied on that email, including my client. And his client, Zampella, is directing everyone in the company to redo the org chart to show that my client is a 9.9% member. Now, his argument about notwithstanding anything...
And if I recall that the statement in the record, Mr. Zambella felt very strongly that after all the work that Mr. Sherman did and all of his contributions to the venture in getting the impossible, a license from New York State to create kiosks for Bitcoins, that was all in there, right?
Yes, that was all in there. And the WhatsApp text messages are Mr. Zampella taunting my client that even if you have 10% of the company, that I am looting everything by pulling all the profits out to Coindado. So 10% of nothing is nothing.
Yeah, but isn't that an admission, though? That he had 10%?
I believe it is. I believe it is a mission by
Because your
Mr.
client was
Zampella.
asking him, I want to know, am I in or not? So he
Yes,
basically at the end
and he's
conceded,
saying, yes,
but-
you have 10%, and they have argued that it's not an admission, that it means something else, and I am responding to that by saying what was going on was Mr. Zampella, in the name of licensing fees, was pulling all the profits out, giving it to Coindado, and saying, you got 10% of nothing, ha, ha, ha.
So how do you address the arguments with respect to the operating agreement, that there wasn't compliance with the operating agreements, and therefore he's not doesn't have a percentage interest in it, and doesn't have a standing, et cetera?
So as you said, I believe, the emails are a written amendment to the operating agreement, so they modified the operating agreement, and the emails said that you vested the second the bit license was issued. That's what that means, vested. At a minimum, it's an issue of fact. This is just not a motion to dismiss argument, it's a summary judgment argument, but it says vested, and the Supreme Court correctly ruled that we have pled that the operating agreement was amended. And then my last point on his argument regarding the contractual language, notwithstanding anything contained here to the contrary, at best, that creates an ambiguity between 3.1 and 3.2, and we have to take some depositions and hear about what the intent was from whoever drafted this agreement, which he admitted at the beginning is not a model of drafting clarity, so I believe he's admitting this is an ambiguity. And please don't forget that even if this interpretation his interpretation is correct, and there wasn't an ambiguity, there's in our brief, in our papers, there's a whole section about frustration of purpose and how they didn't give us the documents. So we couldn't comply with 3.2. It's just absurd to suggest that my client should start drafting documents that they claim are required when there's another email where they instruct Latham and Watkins, go draft the documents that he wants. So I think that's it. Thank you.
Thank you.
Very briefly, Your Honors, our arguments
You have 2 minutes.
Yes. Our arguments with respect to the emails are based on the record because the complaint contains a recitation of who those emails were to and from and what was in them. If the complaint had, it did not allege that Mr. Sherman was copied on the emails. The emails themselves were not attached to the complaint.
You're moving to dismiss on documentary evidence. You didn't have copies of all the documents, including emails that you see fit to submit?
Well, the documentary evidence that the lower court counsel cited, I was not counsel in the lower court, was the operating agreement.
So the emails are irrelevant to that determination. Is that what you're suggesting?
What I'm suggesting, Your Honor, is that it's the plaintiff's responsibility to draft his complaint to state a cause of action. And if there was a more fuller recitation of allegations...
Counsel, we're here to determine whether the granting, whether the denial of your motion, your 3211 motion, was correct or not.
Yes, and the 3211 motion is based on what's set forth in the complaint. Plaintiff could have attached those emails if he felt that there was a need for more.
And you could have attached them since you're the movant on this motion. So if the emails are such a slam dunk for you, why weren't they in the record? Perhaps because it would have shown that the plaintiff received them and therefore the full circle is there?
Well, we can't, Judge, I can't...
This department has held that emails are sufficient written documentation to amend a contract.
But these emails were addressed to an attorney. They may have been, assuming that they were copied on him, which is not pled in the complaint and is not part of the record, he never, even if these were considered to be an offer or a promise or an offer of an agreement. He never responded to them and accepted the terms that were offered. So I think
You're out of time. I'm going to give you 20 minutes, 20 seconds to wrap up.
Okay. Finally, we are not admitting any ambiguity in the argument agreement. Our position is the notwithstanding anything to the contrary clause is an unambiguous statement that everything else is superseded by the new members need to do these things.
Thank you.
Thank you. I'll rest on the briefs.
People versus Charles Jones.
May it please the court, Natalie Allegre, pro bono counsel from Cleary Gottlieb on behalf of Charles Jones. Your honors, at the time of the offense, Mr. Jones was a 27-year-old father of 3 with no prior arrests or convictions. He had a solid history of employment, of bettering himself through education, and of taking care of his family. He's deeply remorseful for his conduct on the day in question. He has served 5.5 years in prison for conduct that, although inexcusable, was explained by his desire to protect a brother who had protected him through 11 years of foster care, including from a sexual predator. For all these circumstances, the court should reduce his sentence as excessive in the interest of justice so that he can return home to his now wife and 4-year-old son. Mr. Jones's sentence of 7 years imprisonment and 5 years of post-release supervision is more in line with a sentence for a second-time offender of the same class felony. His lack of any prior history of violence demonstrates that
But he shot someone in the back. I mean, that's...
Your Honor, Mr. Jones knows that his conduct was serious. He's deeply remorseful, has had 5.5 years to reflect on his actions. That said, without condoning his conduct, there is no evidence on the record that he intentionally aimed the defendant in the back as he was shooting. For example, if Your Honors may recall, Your Honors saying and...
I'm sorry. I just don't understand how you can make that argument. He shoots toward the guy, hits the girlfriend of his brother, and then shoots again as the guy is running out of the store.
Your
and hits
Honors,
him in the back.
That's correct, Your Honors.
If the guy were coming toward him, then maybe you have a little more mitigation. He's trying to protect himself. The guy's running away. You don't have a right to shoot somebody who's running away.
Mr. Jones, I think, has taken responsibility for those actions, feels deeply remorseful, has had time to think and pray for his victims, for them to heal, as he said in his sentencing letter, emotionally, physically, psychologically. That's Your Honors, what's clear from the record is that, one, he had spent 11 years in foster care with his brother who had protected him, that his younger brother, Aubrey, had been killed by neighborhood violence 5 years prior to the incident. It is clear that Hassan, his brother, asked him to go to the bodega, and that is clear from the record that Mr. Jones perceived a threat to his brother. In this context, I think it's fair to say that he panicked and fired the gun. And this is very different from a case like Polanco, if Your Honor saying and presiding justice. Remember, in that case, for example, the defendant had been convicted of first-degree assault, so a more violent crime than Mr. Jones's, and had his sentence reduced in the interest of justice from 12 years to 6 years, even though that defendant had been in an altercation in the lobby, had gone back to his apartment, retrieved his gun, then came out and intentionally shot the victim on the leg, and that Polanco defendant also continued to blame the victim in that case, and he had his sentence reduced by half. Here, again, on the record, even though Mr. Jones would not condone his conduct at all, and he feels deeply remorseful, there's no evidence of the same kind of intent to shoot the person in the back. He was trying to protect a brother who had protected him through years of abuse, and he simply panicked.
Do you know when his conditional release date is?
His first out date is August 2023, Your Honor.
Okay, all right.
And as Your Honor knows, it's also important to mention that he has had at the time of sentencing and continues to have very close familial relationships. He took care of his grandmother, took care of his younger siblings, is now married to his wife, then girlfriend, has a 4-year-old son. And this court has a very particular power to address sentencing disparities, Your Honor. I'll rest for now.
Okay, I'll give you time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court. Robert Butlin for the people. I just want to briefly address some of the points that my adversary brought up. And first, that almost all of the mitigating circumstances that were addressed both in the brief and today were at least available to the sentencing court at the time of sentencing, and were also taken into account by the people in offering this favorable plea deal. Of course, as it was brought up, the victim was shot in the back here. There was no more threat to the defendant or the defendant's brother because he was shot in the back as he was running away out of the bodega. And I should also note that this shooting, of course, took place in a bodega, which is a public place, and the defendant shot twice. So it stands to reason that his reckless shooting could have hurt other people, and of course, one of the missed bullets also hits his older brother's girlfriend in the wrist.
Sir, wasn't the defendant charged with 7 felonies and ultimately pled to 2? But his exposure here to going to jail for a very long time was very real.
That's correct, Your Honor. Had he gone to trial, because the criminal possession of the weapon charges on both the plea and what he was originally charged with could have run consecutively with the top counts, he was facing up to 30 years.
Not likely, though.
Of course, not likely, Your Honor, but
Come on.
of course. But the defendant evidently recognized that this was a good deal and one he should accept. And because it was a fairly negotiated plea, the sentence should not be disturbed on appeal. So unless Your Honors have any further questions, we ask that you affirm. Thank you.
Thank you.
Your Honors, even where the sentencing court has considered all circumstances, this court has the power to reduce a sentence as excessive. Second, it is, of course, he was indicted of higher crimes, but this does not mean that he would have been convicted of higher.
Is counsel right that it was ultimately a favorable plea?
Your Honor, again, it's not clear what would have happened had they gone to trial. Of course, for example, the complainant was uncooperative. It's as the court has recognized, the Court of Appeals has recognized in Thomas, there's uncertainties and risks for both sides, both for the defendant and for the people. In cases like Medina, for example, where the court also reduced the sentence, the court reduced the sentence even though the charges on the indictment were much higher than in the actual conviction. And in that case, I believe it was first-degree manslaughter, and the sentence got reduced from 8 to 35 years to 5 to 15, even though there had been higher charges on the indictment.
Thank you. I want to thank you on behalf of this court, counsel, for your pro bono service, and please extend our thanks to your firm for lending you out to the court for that purpose. We
Thank you, Your Honor.
appreciate it, and thank you. Okay. Last but not least, Bailey versus Gabrielli Trucking.
I think that's
Everything else is submitted. Gutierrez is submitted.
Murray.
Oh, no, you're right. No, not Bailey, I'm sorry. That's why he's looking at me crazy. Murray versus Stone. You're at the end of the calendar. My apologies to you both, and thank you.
Still last but not least.
Still last but not least, even more so now. My apologies to you both. Okay.
Good afternoon, Your
Good
Honors.
afternoon.
Frank Welser on behalf of the appellants who are the plaintiffs below. We are asking the court to reverse the opinion, the order of the court below, and to make clear that under the discovery rule of CPLR 213 subsection 8, the statute of limitations for fraud does not begin to run until the plaintiff has reason to suspect that they have been the victim of a fraud. Only then is the plaintiff under a duty of inquiry. Now, the order granting the motion to dismiss is short, but it suggests that mere possession alone puts one on inquiry notice, thus requiring that person to independently confirm the veracity, accuracy, authenticity.
Not too hard, right? You got a little tape measure to see what the wildebeest's actual measurement was, or whatever the animal was that
It's extremely
your client
difficult,
killed?
Your Honor.
Correct, excuse me?
It is difficult, Your Honor. And the record goes through in detail about how the defendant, Jason Stone, was a master measurer, how Mr. Stone took the measurements, which are all set forth in the record at page 54, Exhibit A to the complaint, took those measurements, which measurements were put down on a scorecard, and the scorecard was then submitted to the governing body of hunting, the Safari Club International, which looked at the scorecards and then, on the basis of the measurements therein, included the animals listed and identified in the complaint in the record books as top 10 and top 20.
I just want to stop for a second, because when you said difficult, there was like a light bulb that went off, because in 2020, an independent measurer was obtained. So what, if any, difficulty or was there to retain someone earlier to do the measurements? Because you had these, you know, what do you call these, the mounts, right? 2001 to 2011. So what was the difficulty, because you had them, you know, to retain an independent measurer, since it was so difficult?
2 points, Your Honor, one legal and the second factual. First of all, on the legal point, this court's decision in Gutkin versus Siegel states that where the circumstances are such to suggest to a person of ordinary intelligence the probability that he has been defrauded, and with that knowledge, the person shuts their eyes to facts which call for an investigation, then knowledge will be imputed to the person. In terms of the facts, the affidavit of Chris Holcomb, which begins in the record at page 217, goes into great difficulty, goes into great detail about the efforts that were undertaken once the plaintiff was suspicious.
The papers talk about comments made by Mr. Stone that raised suspicion.
Yes, about hunting.
Specifically, what were those comments that raised suspicion?
Specifically, and the statement was made under oath, Mr. Stone testified that he would buy large animals at auction and place them in a canned setting until he found a hunter willing to pay a crazy amount of money in order to take it. That raised Mr. Murray's suspicions. That was in 2020. Once, the next month, he had Mr. Holcomb secure a
wait a minute, wait. Say again the statement that made him suspicious?
The defendant stated that he purchased large animals at auctions and then placed them in a setting of his choice, which I refer to as a canned setting, until he found a hunter willing to pay a crazy amount of money in order to shoot that animal. And these trophies were located in Mittagong, Australia, where the defendant's father lived. And first they had to find a qualified measurer. The SCI only takes measurements from qualified master measurers. And it took that master measurer 4.5 hours to even get to the trophies at the place where the plaintiff's father spends time.
That statement seems to suggest that this Mr. Stone would find animals, transport them into a safari area, a park, where he takes his clients to do hunting?
Correct.
And these are animals that are let go in the wild. So even if he were to get an animal from somewhere else and bring it to a particular park for hunting purposes, how does that equal? I'm trying to understand how that statement equals that the measurements of the animals that I've already shot.
It raised suspicions about the hunting activities. If the SCI has all sorts of guidelines about free range and the spirit of free chase, And when the plaintiff heard.
Yes, but anybody who knows anything about safaris know that South Africa is not your best place for safaris. That is not the place where there are the greatest number of animals in safaris.
Well,
it's just not.
At the point where they saw the testimony about this defendant taking animals and putting them in a canned setting, then suspicions were raised. And
Okay, I just want to go back because I know there are a number of allegations about the measurements being significantly exaggerated, like in 2009 and even before, 2001. So what, if any, allegations, since you were on notice, you said significantly exaggerated? Anything about that you couldn't conduct an investigation? You couldn't find a measure-up? Because you said 2001, 2009, significantly exaggerated measurements.
These animals were in the record books. It's like buying an artwork from a
I
noted
don't think that answers my question, because you said they were significantly exaggerated. So you were on notice.
When the second measurer came and measured the curves and the circumference and added them together on a score sheet, yes, there's a difference. But the SCI didn't change, didn't remove the animals from the record books until another qualified measurer submitted them. Mr. Murray's not a qualified measurer. There's nothing in the record to suggest that he is.
Okay.
He runs an investment firm.
You'll have time on rebuttal.
Thank you.
You may proceed.
Thank you. Good afternoon, Your Honor. May it please the Court. Mara Levin, blank Rome, for respondents, defendants. I think it's important to note at the outset that, in fact, possession alone can absolutely constitute enough to give a plaintiff inquiry notice to trigger the statute of frauds. But here, it's not simply possession alone. Here, the alleged fraud goes to the very heart of the reason Murray was engaging in these hunts. By his own admission, in the complaint alone, the possession of these, in the complaint alone, he was an animal hunter only interested in targeting top 10 animal trophies that would go into the SCI record books. He developed this marketing strategy that he would go on these hunts, he'd get it into the record books, and that his business would prosper, and it did. He was the record holder for several of these kills, which was a notable accomplishment and earns him recognition. Years later...
And all of that got wiped out when all of those records were taken off the books.
And he was the one, by his own admission, who submitted it. He submitted it to SCI, and so he was the one who was the...
So we should fault him because he was honest? I mean, that's what you're arguing, counsel. That is ludicrous.
What I'm arguing is that it wasn't until his relationship soured that he decided to have these animals remeasured, that he has said, as Justice Kennedy pointed out, in the complaint, was significantly exaggerated and dramatically different. And he says that in his complaint. Why? He needs to meet the materiality element of fraud. So he can't backtrack now.
He also did not get what he paid for, counsel. Your client is not free of bad faith here.
Well, we're accepting the allegations in the complaint is true for the purposes of this motion, Your Honor. And and as the Gutkin court said, when you have information that would have developed the truth, and you shut your eyes to the facts that call for an investigation, knowledge of the fraud is imputed. So what happened here? He can't turn a blind eye when it suits him to agree with those measures.
What? Stop. What was it that would have put him on notice?
What put him on...
Before that statement that he brings in animals from Australia and cages them, basically.
Okay. So he has possession of the animals during all relevant
Counsel,
times.
I've seen many of these animals, okay? They hang on a wall. Unless you get up there, unless you do the measuring when the animal is received in the crate, once it's up on the wall, measuring is almost impossible.
Your Honor, it's not just a head, it's an entire animal.
I know that.
So if you look at it, I think that an important, an instrumental case that's instructive here is Epiphany v. Levy, which Justice Singh authored. Okay, I submit that that's factually analogous. analogous to this case. What happened there? The court held that a plaintiff could have discovered a fraud in connection with the valuation of an asset. The valuation...
What was the asset in that case?
The asset in that case was extracurricular activities that he had sold.
Clearly, that is not...
But there was no reason. There was no reason when the plaintiff entered into that to suspect that the asset was undervalued.
Look, it seems to me that if your client advertises that he can take people on hunting for the Big Ten, which all hunters, that's all they want are the Big Ten. Otherwise, it's useless, right? It's useless.
Well, if you want to get your, if you
want to be a hunter in safari, what you're looking for are the Big Ten, and actually, really, the Big Six. You're looking for lions, and you're looking for tigers, and you're looking for elephants. Okay?
Your Honor, I think that not all hunters only want the Big Ten. This hunter wanted the Big Ten. That was why he went into hunting, by his own admission.
Why could he not rely on the expertise of Mr. Stone and the acceptance by the hunting association and putting him in the record books? Why could he not rely on that?
Again, I believe Epiphany versus Levy is instructive. Why couldn't the plaintiff there rely on the defendant?
I know you're not asking me a question. You're doing it in the form of an argument, right?
Right, a form of an argument. I'm not asking you. Why couldn't the plaintiff there rely on the defendant? Her ex-husband, who had educational pedigree and an investment banker. She claimed, I was relying on him for the valuation of the asset. It wasn't, when she realized the asset was undervalued, after the statute of limitations had expired, she said, well, I didn't realize it until I had that asset revalued. And the court said, when you sign the asset purchase agreement, you could have, at that point in time, had it valued. You chose not to. If the measurements were that important, this is the reason he developed his marketing strategy. This is the reason he wanted to get into the top 10 record books. If the measurements were that important, and he was accepting it then, turning a blind eye to it, he can't then now, after his relationship sours with Mr. Stone, he can't then decide 10 to 20 years later that he's going to open his eyes, have them remeasured, even though there was no suspicion, and he even admits the suspicion had nothing to do with it. Even though the suspicion was in the 2 years, he said the suspicion had nothing to do with it. Why? Because if that suspicion had no relationship to the measurements, he could have measured them at any time. He chose not to. He chose to accept it then until it no longer suited him, until his relationship with Jason Stone soured, and then he decided he was going to have them remeasured.
Thank you.
Thank you, Your Honor.
Your Honors, I'd like to make three, hopefully quick points. The first is that my colleague mentioned the Epiphany case. And in that case, the court found red flags, just like the court found red flags in the 16-plus cases that we discussed in our reply brief. And the red flags there were that the husband, the defendant husband, she entered into the deal with her defendant husband without obtaining her own appraisals, without questioning disproportionately high rent, which was greater for 10% of the space than for the rest of the entire building, and without verifying whether they had paid the school what was owed, which had not been paid. I won't discuss any of the other decisions. They're discussed at length in the reply. Two additional points on the issue of obviousness. Okay, these are mounts hanging on the walls in Mittagong, Australia, where the plaintiff didn't live. But he stated in his affidavit in the record at page 125 that I did not believe that Stone would intentionally lie about the measurements. Such a lie would be obvious. And then he continues, if there was reason to check, just as an athlete could be caught taking drugs upon a test, or if a fund manager could be caught lying about the good performance of the funds, as what happened with Bernie Madoff. Well, there, the athlete that Mr. Murray was referring to in his affidavit could be caught upon a test. Here, there was a test done once the plaintiff suspected wrongdoing in terms of hunting by the defendant. And he got a qualified measurer whose measurements would be accepted by the SCI to travel to Mittagong, Australia to measure the curves of the horns, add the circumference, and complete the score sheets, which were sent to the SCI. The last point I'd like to make is that I think that this case may not be tasteful. The facts of this case may not be tasteful to everyone, but if there's an affirmance on this case, there will be a flood of cases under the discovery rule in which defendants will argue that the plaintiff had the item in their possession. They had the ring that they bought from a jeweler, they had the painting that they bought from a gallery that they were told was in the catalog raisonné. They had the antique clock that they bought from an antique seller. And in those situations, just because they had the ring, the antique clock, and the work of art, they would, just because they had possession of the item, have a duty to hire someone to check the clarity, the authenticity, the age, the provenance.
Counsel, and you got the red light, and I'm sure everyone wants to leave, is that, as my colleague pointed out, you specifically alleged that there was a significant exaggeration and that the sizes were exaggerated by a foot or more. Now, that to me is important.
I would ask that the allegations be looked at carefully. Significant enough to the SCI that the records were removed from the record books. Now, we could all look at the measurements set forth, in detail in Exhibit A, in the record at page 54, and see, the differences. I mean, I did some quick math myself. I believe that six of the measurements were under 3% in difference. I believe another 4 of the measurements were
One
under
was just an
6%.
inch. One was just an inch, not something that someone would notice eyeballing it.
Yes, and that brings us to how we are entitled as plaintiffs on a motion to dismiss to favorable inferences. And if there's any question about whether an ordinary person would have been on notice that they were probably defrauded, such that they should have launched an investigation into the size of the trophies, that's not for the court to decide on a motion to dismiss.
Thank you.
Thank you, Your Honors.
Okay, we'll do. Yeah, that's it. All righty. Thank you so much. You're welcome. You too.